Good evening. It's November 2nd, 2022. Today I had a lot of chores I needed to do. I bought a little washing machine and it was leaking on those little hoses. So I went back to the place and I go, hey, this is like leaking. It's not good. And I happened to see that they had the same exact model, but a different color. And I thought, ooh, can I exchange it? And they go, yeah. So I have been moving washing machines, dragging them with their little wheels, putting them in my car after having to put down all the seats. That's a lot of work because you have to pull out the leather seat thing to put the seat down and then this down and then take all your stuff out. Oh my gosh, my body hurts. So I did that earlier today and I took a shower and I had my hair up in a little bun and I just put it down and it's still wet. I'm like, oh, great. It's getting colder now, so got a little extra jacket on. It was weird when I went to the gas station. I saw the guy who had sold me the car that I have right now, the used car. Couldn't believe it. I am so shocked. I'm still shocked. I can't believe it. He had told me that his girlfriend died. She was driving a new car. I'm like, did I pay for that car? He says, oh, it's a rental. When she came out, she says, oh yeah, I just got this car. It hasn't even been a month yet to make a first payment. I'm like, the guy is such a liar. Will Tipton, you're so evil. Anyways, it's weird. I noticed my response that when I saw them, I was so happy that the lady didn't die, his girlfriend. She had a baby. They'd take the baby out early because somebody said that she had stage 4 cancer and then she died. She doesn't look like she had any cancer at all. This guy is just a terrible liar. Oh my gosh, one thing after the next. You can't even believe what he's saying. He's like, yeah, your car looks pretty good. You did a good job with the paint. I'm like, yeah, hello. I had to spend $3,500 on new radiator and struts and a battery the next day. Hello. You want to pay for my gas? He goes, oh, I'm kind of broke right now. So I'm just like, I wasn't angry. I couldn't believe my response that I literally hugged them and said, I forgive you. That was bizarre. And the more I think of it, it's so strange because he never even said he was sorry at all. So in my mind, correct me if I'm wrong, but I'm thinking that you only forgive people when they ask you to forgive them. Like, it's not like we're going to start a new relationship. It just happened to be that he was in my town getting gas at the same place. It was weird. But I have a feeling that when somebody asks you to forgive them, it's because they've analyzed themselves and realized that they made a mistake and they want a relationship with you, or they just feel bad and they want to make things right. But this person doesn't have any conscience as far as I can tell. He's just lying to my face saying, oh, that's a rental car, when she said that they bought it. And I did buy that car for them when he sold me his little lemon. But nevertheless, I am doing what I can with what I have. But do you guys find that if you get sinned against or transgressed against, or someone harms you or something, it just eats you, like it just eats at you? Like, I can't believe I was that naive to believe the person and that they were telling me lies the whole time. Like, I don't know what to do about that. It's weird. I'm starting to think that I need to pay attention to every little tiny thing. Like before, I guess, I don't know. it's like when I, talk about every little tiny thing, sometimes people's reactions they're like, gosh, you're annoying, blah, blah, blah. But I'm starting to think that I do need to pay attention, because when I went and bought that washing machine, did not know that the hoses, they didn't have them included. And on the outside hose was shredded. I didn't even pay attention to that. I thought, okay, cool. Bulldog Liquidators. You got a deal. You're going to give me a deal. But no, they even sell things that are damaged, like a thrift store or something. I think it's a thrift store. And I didn't know that. I thought it was like liquidation. They got rid of stuff that was good at the store. But no, I have a feeling that a lot of these things got returned. So it was so much work the last 3 days. Lifting the washing machine had 2 wheels on it, so that worked. I had to take back a dolly, didn't need that. Take back those other things that I didn't need after all, because I ended up switching it back with the new one. But I think what I'm trying to notice is that I just need to double check and check, because like I believe what people say, and they either are just saying it, because that guy told me, I said, the first guy at the Bulldog Liquidators, I said, is this washing machine new? He goes, it looks new. And it had tape across the front of it and like clear looking plastic stuff. So I'm like, cool. So I'm thinking when I open it up that the stuff is going to be in there and the instructions and all that. No, there was nothing in there. And it had a big gash on the front when I took the tape off. And I'm thinking, how evil to tell me it's brand new when it's not brand new. Then to just conceal that it had a big gash. And then when they say that they test stuff, they didn't test this one. So then they said, when I was on the phone, they said, well, if we find another one that's just like it, we'll save it for you and we'll put your name on it. So I go back the next day and I see for myself that there was another one exactly like it, different color, but it had all the hoses. It even had all of the instruction manual. And this one looked really brand new. There was just one defect on the cord on the outside that looked like it was ripped, but it didn't work. It wasn't anything about the inside wires, it's just the outside coating. And I thought, cool. So I just brought it home, but all because I listened to the salesperson, or I listened to what they told me, but I didn't do my due diligence of inspecting every little thing. Is the exact same situation with me buying the car after I had a head-on collision. The guy was being all nice, says, hey, I can give it to you for free. I got a really good deal on it, blah, blah, blah. And I'm thinking, cool. Then I go, you better ask your girlfriend, because, she might get mad. They go, well, we are having a baby on the way, and so we need to get a bigger car. Well, this car I just saw at the gas station was smaller than the one that they sold me. And then they even got rid of an extra kid because the kid was over at a different parent's house. And I'm thinking, what the heck? So this is the thing I'm trying to say, is that people can be genuinely deceived and genuinely telling you what their truth or belief is. Even me. Everybody. But it is really up to us to do our due diligence and to research things. Because we can't just go by what other people say, because number one, there's going to be liars. Number two, they want to make a sale. So they're going to be a liar. And number three, some people just, it looks new, but they didn't do any, investigation on it. So I said all that, which is true, to say that we are going to have to do the research and do the reading ourselves. And I'm really thankful for PJ. He had given me his notes on some trust, and I thought maybe this might be a good time to read it. Since my body is aching here, kind of have to sit down and take a look at some stuff. All right, so let me see, how do I make this a little bit bigger? Command plus. Oh, wow, I really made it bigger. Let me see if I can get rid of this other background stuff here. Okay. Thanks, PJ. I really appreciate you helping me out. Yeah, he's really good about reading and taking notes. And you know, we need to be good at reading and taking notes too. So sometimes when you take notes, though, you're just like blah, 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 listening and not really spelling right, but that's okay. I know how to overlook all that kind of stuff. Command minus. Let's wait. Command plus. Let's try it again. That's extra big. Command minus. Let's go back here. Okay. So let's see what the handbook on the law of trust. Oh, isn't that an interesting thing? You know, that word trust. I trusted people that they were telling me the truth. They were liars. They broke my trust. That's not good. So this is a different kind of trust, I think. Let's find out. So this is the handbook. These are notes, by the way. The Handbook on the Law of Trust by George GLEASON, Professor of Law in the Cornell Webb University College of Law. Chapter 1, Introductory and History. Definition of fundamental terms. 2, Origin of uses and trusts. 3, Uses and trusts before title statute of uses. Oops, what happened? Okay. The effect of the statute of uses and 6, trust in America. Definition of fundamental terms. A trust is a relationship in which one person is the holder of the title to property, subject to an equitable obligation to keep or use the property for the benefit of another. The settlor of a trust is the person who intentionally causes the trust to come into existence. The trustee is the person who holds the title for the benefit of another. Oh. Interesting. The trust property is the thing, real or personal, the title to which the trustee holds, subject to the rights of another. I feel like my rights have been violated. Who's the trustee of my trust? I want to know. I want things to happen because I can't believe I just... I have trust issues. So the Sestake trust is the person for whose benefit the trust property is held or used by the trustee. The Sestake trust is the person for whose benefit the trust property is held or used by the trustee. The trust property. It should first be noticed that specific property, real or personal, is always an element of the trust. In certain somewhat analogous relations, men only, or men and any property may be involved, as for example, an agency where A may be the agent of B for the performance of personal services which have no connection with any property or no connection with any particular property. Page 2 on the left says the trust parties. It is customary to think of 3 persons as connected with every trust. Oh, I've heard that before. Namely, the settlor, the trustee, and the Sestake trust. But since where the settlor declares himself a trustee, settlor and trustee are one and the same person. A trust may exist with only two parties. In some trusts, there is no settlor. These are the implied trusts created by the law. Because it's presumed that the parties intended a trust to exist for the purpose of accomplishing justice. In these implied trusts, no individual intentionally brings a trust into being. Right. The court gives life to the trust. But the acts of one or more persons have caused the court to decree the trust existence. Let me read that last part again. But the acts of one or more persons have caused the court to decree the trust's existence. The settlor is also sometimes called the creator of the trust or the trustor. The phrase sestike trust is synonymous with beneficiary of the trust. The trust rights and duties. The trustee holds the property for the benefit of the sestike trust. It is unnecessary now to consider how the sesta may obtain that benefit. The methods vary greatly according to the terms of the particular trust. In one case, the trustee may have no duty except to hold the property, and the sestike trust may take the profits directly. In another instance, the trustee may be charged with the obligation of detailed management, and the sestike trust may receive the benefits indirectly. The trustee's obligation is said to be equitable. Originally, it was recognized only by the English Court of Chancery, which alone administered the rules and applied the principles of equity. Many definers of the trust make enforceability in a court of chancery or equity a part of their definition. But in the present state of the law, it is deemed preferable to define the trustee's obligation as equitable and to omit any reference to the court in which this obligation may be enforced. In England and in many American states, the separate court of chancery has been abolished. Yeah, that's what I thought too. And both legal and equitable obligations are enforced by the same court. On the other hand, in a few states, the separate court of equity is maintained. The trustee's obligation is based on equitable principles, whether enforced by a court having both legal and equitable jurisdiction or by a court having solely equitable functions. It seems wiser to omit all reference to the form of enforcement. Whether the right which the sestee has is a property right in the subject matter of the trust, a right in rem, property, or merely a personal right against the trustee, a right in personam, is a question much debated. I heard that when you come in personam, that means you're in person. Origin of uses and trusts. 2. Trusts in their early development in England were divided into two classes, namely special or active trusts, and general, simple, or passive trusts. The latter were generally called uses. So simple or passive trusts were generally called uses. Prior to 1535, uses constituted by far the more important class of trusts. Uses were introduced into England shortly after the Norman conquest, 1066 AD. They were patterned after the German Truhan or Salmon. The principal objects of their introduction were A, to avoid the burdens of holding the legal title to land. I need to pay attention to this part. To avoid the burdens of holding the legal title to land, such as the rights of the lord under feudal tenure, the rights of creditors, and the rights of dower and courtesy. B, to enable religious houses to obtain the profits of land, notwithstanding the mortmain acts. C, to secure greater freedom in conveying land inter vivos. Oh, I've heard that before. Viva, vivos, life, thing alive. D, to obtain power to dispose of real property by will. The use was a trust in which the trustee had no active duties, but was merely a receptacle of the legal title for the Sestake trust. The words use and trust are employed as synonyms frequently by writers and judges. However, there is a distinction in their meanings. Prior to the Statute of Uses in 1535, there existed in England a relationship known as a trust. Trusts were of two classes, namely active or special, and passive, simple or general. In cases where a trustee held property for some temporary purpose and with active duties to perform, the trust was called active or special. Thus, if A conveyed land to B for 10 years, to take the profits of the land and apply them to the use of C, B was an active or special trustee. These trusts were comparatively rare prior to the Statute of Uses, but if the legal title was transferred to one as a permanent holder for the benefit of another, but with no positive duties of care or management, the trust was called general, simple, or passive, or a use. Page 4, the Statute of Uses. The Statute of Uses provided that wherever any person should therefore be seized of land to the use of another, the latter should be deemed the legal owner of such lands, and the taker subject to a use that should have no interest in the lands. The object of this statute was to convert the equitable interest of the Sestake use into a legal interest, and thus A, prevent the loss of feudal rights by landlords. B, obviate fraud on creditors, alienees, dowerses, and tenants by the courtesy. I don't know what that means. C, probably to injure the religious orders, which were the beneficiaries of uses. The effect of the Statute of Uses. The Statute of Uses did not have its intended effect because A, by virtue of its express provisions and because of the construction given it by the courts of law, certain equitable interests were not converted into legal interests, namely equitable interests in personal property, uses of estates less than freehold, active trusts, and uses upon uses. These equitable interests not so converted into legal interests, were recognized and enforced by the Court of Chancery as trusts after the statute of uses, and formed the basis of the modern law of trusts. A debtor may, with certain exceptions unnecessary to mention here, do as he like with the money he receives from his creditor, or with his property generally. A trustee will be guilty of the crime of embezzlement if he converts to his own use the trust funds. The specific nature of the trust property requires him to keep it separate from private use. The specific nature of the trust property requires him to keep it separate from private use. As previously stated, the trust is an obligation resting solely on equitable principles and originally enforceable only in Chancery. In a great variety of ways, equity will act upon the trustee and compel him to do or refrain from doing certain acts. The debtor's duties, however, are legal and enforced by an action to recover the amount of the debt ordinarily. Equity may, of course, aid the creditor, but the primary method of enforcement is by legal remedies. When a trustee states his accounts with the custody and admits that a certain sum is due him, the trustee may change to a debtor. Ooh, yeah. I'm thinking in the back of my head about a timeshare that I have. They say I'm the owner, and I pay the taxes on the property taxes once a year. And I also pay the maintenance fees and the club fees. Well, today I sent out the coupon, the remittance coupon, and I made it a money order for the maintenance fees. And when I looked up, by the way, I went on the Secretary of State website. I looked up the place that I'm sending the money to, Lake Tahoe, whatever it's called, and it's in Florida. And I also found out that it's considered a nonprofit. And I'm thinking, oh my gosh, this whole time, for maintenance fees, that's kind of what they stick you with. The higher your points are, the more maintenance fees. It could be up to $1,000, but a year. But it was nonprofit. So does that mean that I've been gifting it to them for free? To their church, their religious organization? Oh, and guess who's the, what's it called? The registered agent. Lawyers. Yeah. That means it's a trust. I thought it was purchase of a timeshare, but no. They looked at my credit. They probably had the Social Security number on the application. They got paid ahead of time. I gotta nail these guys. I gotta go there. I keep talking to them every year, and they keep avoiding me. So it's time to file some reports. Well, I did that actually, FTC, I did it, but that thing just looks like, yeah, until we get enough reports of people, yeah, whatever. I don't think that they do anything. So I went ahead the first time and did the coupon instead of actually deducting it from my bank account. So we'll see what they have to say, because I made a payment. It's called tender. I made a tender. Anyways, let's move on. So I'm paying attention to this debtor, and trust thing. Practical distinctions between debt and trust. In the following situations, difficulty is sometimes experienced in determining whether there is a debt or a trust. That's what I'm talking about. A, where negotiable paper is deposited for collection. B, where agents and factors receive money for their principals. C, where money is delivered to be applied to a specific purpose. An unrestricted endorsement, would pass title, to the instrument to the collector. And since ordinarily he would not also be the beneficial owner, he would seem to be properly a trustee. But if the endorsement were restrictive, in that it was for collection, title would not pass to the collector, although he would have power to sue on the instrument, and he would be a mere agent. Occasionally, the collecting bank prior to collection is called a trustee. What is it? She wants to go outside. Or a bailee of the paper. Money left for investment has generally been considered a trust fund, unless the element of interest, payment pending, actual investment indicated a debt. A delivery of a check and cash to a bank, the sum represented thereby to be transmitted to Italy, and there placed to the credit of the depositor in a bank, has been held to create a trust. What is it? You want to go outside? Okay. All right, hang on. I got to stop and pause for just a second because she needs to go outside. Okay, I'm back after about 30 minutes of going in my trailer, blowing it out, seeing if there was a rat in there, which I think there were, or is. Karma's out there. She's going to take care of it. At least, for now. Okay, so here's the last paragraph on page 5. In the second place, the holder subject to an equitable charge is a beneficial holder, whereas the trustee is not. If B received property subject to a charge of $500 a year in favor of C, and the property produces $1,000 a year, B may retain the surplus $500 for his own use. Really? Well, that sounds great. I have a feeling that those maintenance fees are probably a check. Yeah. Wow. Contrariwise, if B were a trustee of the same property for the purpose of paying C $500 a year, B could not keep the extra $500, but would be obliged to hold it for the benefit of the creator of the trust or for his heirs or next of kin if the settlor were dead. The holder, subject to a charge, is entitled to all benefits from the property beyond the amount necessary to satisfy the charge. The trustee is never entitled to any beneficial use of the trust property. Cool. Okay, so that management company is the trustee. And we are the beneficiaries of the trust, the SSTK. The trustee is never entitled to any beneficial use of the trust property. So now I just realized that I'm not the trustee. They are. I think I did the right thing today. Assignment of a chose in action. Ooh. An assignment of a chose in action at common law differs from a trust, in which the subject matter is a chosen action, in that A, the assignee's remedy is solely at law, while the cestacate trust is equitable. B, the assignor's duty is purely negative, whereas a trustee always has some positive duty. Let's go over A and B again. A, the assignee's remedy is solely at law, while the cestacate trust is equitable. B, the assignor's duty is purely negative, whereas a trustee always has some positive duty. You gotta know what hat you're wearing then. Executorship. An executor differs from a trustee in that A, the rights of the legatee against the executor are legal, enforced through a probate or law court, while the cestacate trust remedy is equitable. B, the executor's duties toward the property in his control are temporary duties of collection, conversion into money, and disbursement, whereas the trustee has more permanent functions of administration and management. I'm wondering, like, as far as like property tax from the in the county, I think that they might be the trustees because they're the ones that do the administration and the management. Like when they send you, here's your tax you need to pay, I think they're the trustees. But the executor's duties toward the property in his control are temporary duties of collection. Oh, maybe they're the executors. Conversion into money and disbursement, whereas the trustee has more permanent functions of administration and management. If the officer be an executor, the rights and the claimant against him are legal and will be enforced through probate or law courts, while if the officer be a trustee, as we have seen, it is only principle of the Court of Chancery which enable the claimant, the cestacate trust, to obtain the benefit of the property. Whether the officer in question is an executor or a trustee can only be told by an examination of the work which the testator expects him to perform. An executor is required only to collect his testator's property, reduce it to cash so far as it necessary for the payment of debts and legacies, and pay the debts and legacies, period. An executor is not ordinarily expected to invest the funds, collect the income, and make periodic payments over a long series of years. Such duties of more or less permanent administration mark the trustee. The distinction between the office of executor and that of a testamentary trustee lies in the duties imposed upon them respectively. The duty of an executor as such and his duty as a trustee of an express trust under the will are entirely different. As executor, it is his duty to collect the property and pay the debts and general legacies, while as trustee, it is his duty to invest and manage the particular fund or trust estate in accordance with the directions of the will. Okay, I gotta go outside and get my dog because she's screaming bloody murder at those rats under the trailer. Okay. All right, well, I gave her access to getting inside of the, whatchamacallit, trailer next door, so put a light on in there. I have a solar thing going. All right, so where were we here? Okay, I know we read about the assignment of chosen action and executorship. Got down to will. So now I think we're up here on powers. A beneficial power bears no resemblance to a trust. A power in trust is a trust in which the trust res is a power to dispose of property. Powers are beneficial and in trust. A power is beneficial where no person other than the grantee has, by the terms of its creation, any interest in its execution. Wills. A trust which provides for benefits to commence at the death of the settlor, and in which a power of revocation is reserved to the settlor, nice, differs from absolute devise or bequest in that the rights of the Sestake trust arise up on the execution and delivery of the trust deed, whereas the rights of the legatee or devisee arise only at the death of the testator. Occasionally, it is difficult to decide whether a given disposition of property was testamentary or created a trust which provided for benefits to begin at the death of the settlor. If the instrument gives the creator of it the power of revocation during his life. If the instrument gives the creator of it the power of revocation during his life, which he has in the case of a will, and provides that the interest of the donee shall commence at the settlor's death, the only important distinction between the trust and the will is that the trust deed takes effect at once and creates a vested or contingent right in the cestee, dependent on the terms of the trust instrument, while the will takes effect only as of the date of the testator's death. A debtor may, with certain exceptions unnecessary to mention here, do as he like with the money he receives from his creditor. Do as he likes with the money he receives from his creditor, or with his property generally. A trustee will be guilty, of the crime of embezzlement, if he converts to his own use the trust funds. The specific nature of the trust property requires him to keep it separate from private use. The specific nature of the trust property requires him to keep it separate from private use. Money paid to agents or factors. Where money is paid to one for the use of another, or as the proceeds of another property sold, it is sometimes difficult to distinguish trust from debt. The general rule, however, is that such persons as commission agents, receiving the proceeds of goods sold, insurance agents, collecting premiums, an agent to sell bonds, and a collector of rents are trustees of the money. So coming into their hands. But an attorney collecting money for a client is not a trustee, but rather a debtor. What? That's wild. An attorney collecting money? For a client. is not a trustee, but rather a debtor. Wow. Promoters of corporations have sometimes been loosely called trustees for the corporation to be organized or its stockholders. The promoter, like the trustee, is no doubt a fiduciary. He occupies a position of trust and confidence, where he has unusual opportunities to take advantage of others, and where he is prohibited from acting for his individual interest in any way. But he is not a technical trustee. He holds title to no definite property for the benefit of others. The corporation is not yet in existence. He cannot be a trustee for it. He does not hold any definite property for the prospective stockholders' benefit. Such property as the promoters become the owners of in preparation for the organization of the corporation they own absolutely. Their position seems to be that of anticipatory agents. The promoter may become a trustee for stockholders or a corporation. Thus, if he makes a secret profit for himself out of transactions with the corporation, equity will fasten a constructive trust upon such profits in favor of the stockholders. But such a trust arises out of wrongdoing by the promoters. In their normal relation, promoters are not in any true senses trustees. If the instrument gives the creator of it the power of revocation during his life, which he has in the case of a will, and provides that the interest of the donee shall commence at the settler's death, the only important distinction between the trust and the will is that the trust deed takes effect at once and creates a vested or contingent right in the cestee, dependent on the terms of the trust instrument, while the will takes effect only as of the date of the testator's death. So far as their legal effect is concerned, the characteristic distinction between a will and a trust is that while the former becomes operative only at the death of the testator, a trust passes an interest to the trustee and beneficiary. Ooh, that's good to know. Instantly upon the execution and delivery of the writing by which it is created. All right, I gotta stop again. I gotta go get my dog outside. Okay, sorry about that interruption. Let's get back to it. Let's see. So, I think we talked about the difference between express and implied trust, right? So, in considering the origin of trust, two classes are usually fixed. Those trusts which come into being because the parties concerned have formed the actual intent that they shall arise, have expressed that intent in written or spoken words or otherwise, and have made the requisite property transfers, are called express trusts. Thus, if A executes a writing whereby he declares himself trustee of certain lands for B, using the words trustee and cestocate trust, and describing the particular land as the subject of the trust, there is an express trust. So let me look at that again. Thus, if A executes a writing whereby he declares himself trustee of certain lands for B, using the words trustee and cestocate trust, and describing the particular land as the subject of the trust, there is an express trust. Precatory expressions, construction of particular words or phrases. The following phrases have been held to show an intent to create a trust for the education and support of, for the support and maintenance of. Oh, I've heard that when we do the maintenance fees. Wow. Oh my gosh. For the support of shall be held, controlled, and invested by my executors for upon condition that he pay for herself and 3 children. On the other hand, oops, what happened? Oh, what's okay. On the other hand, the following words have been construed as failing to show an intent to establish a trust. To A, the use of my farm. Mo A, for his use. To my daughters. The income from certain property. To A, for the purpose of dividing the same among needy relatives. To A, to keep for the depositor. TDA, to be paid by him for furnishing necessaries to the grantor at cost prices. Declaration of intention to apply specific property to payment of a specific debt. To a son in full confidence that the son would make a proper adjustment of relations to other children. Language must describe trust elements completely and with certainty, uncertainty, and ambiguity in the description of the trust elements tends to show that no trust was designed. But if the intent to create a trust be assumed, it cannot be effective unless the trust elements are properly described. Those elements are the subject matter, the trust purpose, the cestui trust, and the trustee. First, the writing must contain a complete statement of the trust. To take the case out of the statute of frauds, the trust must appear in writing under the hand of the party to be charged, with absolute certainty as to its nature and terms before the court can undertake to execute it. Oh, man. Okay, I had to go get her. Whew, I'm glad she finally got in. All right, where were we? Okay, I think it was over here. Oh, darn it. It was on 9. So it was over here. First, the writing must contain a complete statement of the trust. Right. To take the case out of the statute of frauds. So we read that. All right. So where there is not sufficient identification for the trust res, for example, the memorandum is defective. But the length of the trust period is not stated in the memorandum is not important, since the trust will last as long as necessary to accomplish its purpose. Once the owner of the property has placed the legal title, pay attention to this, in the trustee and created the equitable right in the cestui trust, the trust becomes enforceable. If the trust has come into existence, the question whether the settlor received value for his act of settlement is immaterial. The creation of a trust is but the gift of the equitable interest. An unequivocal declaration as effectively passes the equitable interest to the Sestake trust as delivery passes the legal title to the donee of a gift inter vivos. I have a feeling that a lot of us with deeds may have given legal title to the state, especially with your car, as a donee of a gift inter vivos. I don't know. That's kind of what I'm reading. But if you guys know anything different, put it in the comment section. It is sometimes said that voluntary executed trusts are enforceable, but that voluntary executory trusts are of no effect legally. A trust may be said to be executed when it has been perfectly and explicitly declared in a writing, duly signed, that means 2 signatures, in which the terms and conditions upon which the legal title to the trust estate has been conveyed or is held. Oh my gosh. I looked up on the county and I talked to the county assessor or whatever, but they said, I said, this deed that I have only has 1 signature. There's no 2 signatures on it. It's just 1. They said, oh, that is just for our records to show that they're transferring over it to you. That's not the contract. That's just the deed. That's their responsibility to file it. You didn't need to sign that. I have a feeling that I am not the owner. They're just sticking me with the liability, that's all. And I get the usage. So I got to figure out which one am I here. And the final intention of the creator of the trust in respect thereto appear with such certainty that nothing remains to be done except that the trustee, without any further act or appointment from the settlor, carry into effect the intention of the donor as declared. Donor? Was I a donor? I think I might have been. But there is objection to the use of the words executory and executed. In this connection, since the phrase executory trust is somewhat ambiguous, not clear, it is sometimes employed in another sense, namely to indicate a trust, the details of the execution of which are not definitely fully laid down in the original instrument, but which may nevertheless be completely created. Disposition of trust instrument 23, where the settlor makes himself trustee. Delivery of the declaration of trust to the beneficiary is not requisite to the completion of the trust. If the creator of the trust transfers the title to another to hold in trust, delivery of the trust deed to the trustee is necessary only. What happened? Only, where was I? Well, where is it? If the creator of the trust transferred title to another to hold in trust, delivery of the trust deed to the trustee is necessary only so far as the rules of conveyancing require delivery to pass property. The instrument need not be manually handed over to the trustee. Placing the trustee in possession of the trust instrument in such a trust is not necessary or natural, except as required by statute in a few states. The recording of the, here we go, the recording of the trust document is not necessary to the creation of the trust. Notice of the trust 24. Neither notice to the trustee nor to the cestui trust is essential to the existing of a completed trust, but the lack of such notice may have evidentiary value in showing that the settler did not intend a completed trust. Notice to the cestui trust is notice to the beneficiary, a prerequisite to a complete trust. Obviously, the cestui cannot bring suit to enforce the trust until he knows of it. But the trust may nevertheless exist without his knowledge. That's what I think is happening. I think, like in my example of me having a timeshare, it was a trust, and I didn't know about it, but now I do. If the settler's intent is clear that a trust shall arise, failure to notify the beneficiary of such intent will not be important. The question in such a case is not so much whether, in the lifetime of the decedent or decedent, the declaration was actually exhibited to the inspection of others, as whether, under all the circumstances of the case, it would appear to have been written and preserved for the inspection of others. Ooh, acceptance! This is what that one lady was saying, Amila, about acceptance. Oh my gosh, and I did call. I called them and I left a message and I said, I don't ever remember accepting the deed. I never had it recorded because I didn't know to accept it. But guess what? That's because it is a trust. Yeah, I do need to do it. So here it is right here. Acceptance of the trust by the beneficiary is presumed, and proof of express acquiescence, silence is acquiescence, in the trust by the cestui is not essential to the completion of the trust. Okay. Likewise, acceptance of the trust by the trustee is not a requisite to the creation of the trust, or if the trustee nominated does not accept, equity will appoint a substitute. Oh, how much you want to bet the substitute is the one like the Secretary of State or something like that, or whatever, the DA, or I don't know. Hang on. Acceptance of the trust by the trustee is presumed. Well, that's what I think the state is presumed to be the trustee. Wow. Acceptance by the cestui trust. No man can be compelled to become the owner of a property. To become the owner of property. The transferee or donee must assent. The creation of a trust involves the transfer of rights to the cestui. It follows that acceptance of the trust by the beneficiary. Whoa, did you see that? Acceptance of the trust by the beneficiary must occur before the trust will be complete. Oh, so we do have to accept it. Just as the grantee of real property, that's what I'm being taxed on. Just as the grantee of real property must acquiesce in, darn it, where is it? In the deed to him before the grantor's title will pass to him. Gotta read that again. It follows that acceptance of the trust by the beneficiary must occur before the trust will be complete, just as the grantee of real property must acquiesce in the deed to him, excuse me, before the grantor's title will pass to him. But the law presumes that the transferee of beneficial property rights accepts them. Whoa. The law presumes. Commonly, the rights of the Sestake trust are purely beneficial and not burdensome. Hence, in the ordinary trust, there is a presumption that the Sestake trust assents to the trust. No express proof of acceptance of the trust is necessary, but if the gift of the trust interest imposes onerous conditions, excuse me, the consent of the beneficiary will not be presumed. But if the gift of the trust interest imposes onerous conditions, what does that mean? The consent of the beneficiary will not be presumed. Okay. Acceptance by the trustee. No man can be compelled to accept the duties of a trusteeship. Hence, for the purpose of fastening the trust duties upon any given individual, proof of acceptance by such individual is necessary. No formal acceptance of the trust is needed. Acts in performance of the trust show implied acceptance, but oh my gosh. When we pay bills, that is an act of performance that show that we implied acceptance to be the trustee. That's why they call us the trustee. Oh my gosh. But acceptance by the trustee originally named is not essential to the creation of the trust. Equity will not allow a trust to fail for want of a trustee. Even the neglect to name any trustee will not be fatal to the perfection of the trust in the ordinary case. Hence, the rule is general that proof of acceptance of the trust by the trustee is not an essential part of the evidence necessary to show that an express trust has been established. It is said indeed that the trustee never accepted the trusts of the deed, and hence that it was incomplete. It is not essential to the validity of the trust. Oh, darn it. Created by the beneficial owner of the trust property, that there should be an acceptance or a declaration of the trust by the trustee in whom the legal interest is vested. I'm going to read that last part again. It is not essential to the validity of a trust created by the beneficial owner of the trust property that there should be an acceptance or a declaration of the trust by the trustee in whom the legal interest is vested. So they made us trustees when we purchased the house, the car, the timeshare, whatever it is, because we have the legal interest is vested. We're the ones that are legally obligated to pay because they made us the trustee, and our actions show when we pay that bill that we're operating as the trustee. That's what I'm seeing here. All right, so cannot hold beneficially. Whoa. Whoa, but rather solely for the use of another. If the trustee declines the trust in advance of the settlement, the result will be that the settlor, or in case of wills, the testator's heirs or next of kin, will hold the property in trust for the sestike trust. If the disclaimer of the trust occur after the trust has been perfected, the legal title to the property will vest again in the settlor, or in cases of wills in the testator's heirs or the next of kin, subject to the trust declared. So in that trust deed that I have, or excuse me, deed that I have for my timeshare, it does say in perpetuity, meaning that the testator's heirs or the next of kin will be subject to the trusteeship of having to pay the property taxes and the you know, the maintenance fees and all that other stuff. But what I'm confused about is that I'm actually, you know, the beneficiary. I get to play. I get to go there. I paid, I get to play. But then they're just trying to keep us on, okay, well, these services that we offer you for maintenance, and if you want to go to other properties that we own, you got to pay this. I'm thinking, am I really the owner? I guess I could probably just go to my timeshare, that 1 week thing, but you know, the club thing is where you can go other places. And that's what I like to do. So disposition of trust property. 26, transfer of title in the trust res to the trustee is fundamental to the idea of a trust and an important step in the act of creating a trust. This is what they did. The investing of the trustee with possession of the property is not necessary to the completion of the trust, except insofar as possession is essential to the passage of title. Transfer of title. The very definition of a trust involves the idea that the trustee shall be the holder of a title to property. Yeah, that's what I got. I have a deed. So they made me the trustee. I'm the holder. of a title to property. Oh my gosh. Hence, transferring title to him is one of the acts which the settler must perform before the trust can be complete. To create a trust of this species, it is essential that the delivery of the property to the alleged trustee, that's what I guess I am, alleged trustee, be with the purpose and intent of passing the legal estate to the trustee and vesting in him the absolute control over the property, even as against the person creating the trust, subject only to the declared purpose of the trust. And if such original owner reserves to himself or his heirs the power to control the property, and has only vested in the alleged trustee a possession, without any intention of vesting the property in him, but simply for the purpose of constituting him her agent. Oh, that's what I think I am, as an agent, to do certain acts. Whoa, oh my gosh. And at the same time of reserving the power to dispose of the property at his or her will, with or without the concurrence of the trustee, this would be an imperfect trust and would not vest title in the trustee. Right, what's going on? Huh. Can they do that? Can the state do that when you buy something? Create an imperfect trust? Or maybe this is regarding something else. Because I have title. Whether the trustee must become the holder of a legal or, did you see that? Or, oh my gosh, that's exactly what they did. Or, they made me the legal title and they have the equitable title to the property. Oh my gosh, that's exactly what it is. Oh my gosh, we're a partnership. There's 3 of us. Them, me, and the person, the legal person. So they made my legal person the legal title. Oh my gosh. And then they get the equitable title. And I, the living woman, get to be the beneficiary and go to the timeshare. Wow. Whoa. Before the trust can be complete, depends upon the nature of the title, which the settler intends the trustee shall have. Ordinarily, the settler transfers to the trustee the legal title. That's what happened. But occasionally, he places in the trustee's hands the equitable title to the property to hold in trust for the beneficiaries. Interesting. I have a feeling that the timeshare has the equitable title to the property to hold in trust for me. Now I'm alive. Here I am. Whatever title the trustee is to have during the administration of the trust. Oh my goodness. All those remittance coupons. Oh my gosh. Oh, we've been donating. We've been donating money. They've been cashing in the coupons. They've been double dipping. Oh my gosh. All I need to do was give them back the coupon and sign it and not be putting my money to it. Whatever title the trustee is to have during the administration of the trust must be given to him before the trust can be said to be completely created. If the property owner makes himself the trustee, how do you make yourself the trustee? The transfer of title is formal or theoretical. But if a third person is to become trustee, the transfer is actual, and the formalities necessary to convey the title to real or personal property from one to another must be complied with. In order that there may be a complete trust, the interest of the Sestake trust, whether regarded as an estate or as a right in personam, right there, you gotta show up in person, must be presently vested in him and not made contingent. Savings Bank Trust 27. That, okay, Savings Bank. This is different now. That, page 13. That one has deposited his own money in a bank and directed that the account be entitled in trust for another does not alone establish a trust in the bank account. Wow. Depositors are frequently actuated by other motives than trust intent in making such deposits. The courts require confirmation of the trust by other acts. All right. Acts confirmatory of a trust intent are express statements by the depositor that he intended a trust, allowing the deposit to remain until the depositor's death. Notice of the deposit to the beneficiary. Notice to a third person. Delivery of the bank book to the beneficiary or a third person, making a will consistent with a trust intent, and payment of part of the deposit to the supposed cestui. Near relationship between depositor and cestui tends to strengthen the notion of a trust. The attitude of the courts toward a deposit entitled in trust, is well stated by Andrews J. Beaver versus Beaver. The form of the account is the essential fact upon which the plaintiff relies. Implied trusts are trusts declared to exist by courts of equity, either for the purpose of carrying out the presumed intent of the parties or to rectify fraud and prevent unjust enrichment. They are of two classes, namely, A, resulting trusts, which are declared by equity to exist because of a presumed intent that they shall exist, and B, constructive trusts, which are created by equity as a convenient means of rectifying fraud and preventing unjust enrichment. Undoubtedly, a desirable division would be that of Professor Costigan into intent enforcing and fraud rectifying trusts. Within the former class would fall, number one, cases where the parties have clearly expressed an intent to have a trust exist. Cases in which the parties have expressed an ambiguous intent, which the court, construing their acts, holds to be a trust intent. And three, cases in which parties have expressed no intent by words, but have done acts from which the court presumes that a trust was intended. The one furnishing the value may furnish it directly or indirectly, but in either case, equity presumes that he intended that some interest should accrue to him in return for such value. Wherever equity finds a holder of the legal title to real or personal property who has furnished no consideration for the transfer of that legal title to himself, equity presumes that the person who furnished the consideration for such transfer intended that the holder of the legal title should be a trustee for the payer of the consideration. I gotta read that part again. So, wherever equity finds a holder of the legal title to real or personal property who has furnished no consideration for the transfer of that legal title to himself, like he didn't pay for it, equity presumes that the person who furnished the consideration for such transfer intended that the holder of the legal title should be a trustee for the payer of the consideration. The further definition of resulting trusts can best be accomplished by a consideration of the various cases in which they have been held to arise. Use of trust funds for purchase of property. 34. If a trustee or other person occupying a fiduciary relationship use the funds of his beneficiary or principal with the consent of the beneficiary or principal for the purchase of property in the name of the trustee or other fiduciary, a trust is presumed to result in favor of the beneficiary or principal. Constructive trusts are created by courts of equity whenever the legal title to property is found in one who is not an express trustee, but who is not equitably entitled to retain such legal title. They are based on fraud, actual or constructive, or other wrongful conduct and are sometimes called involuntary trusts or trusts L maleficio, ex maleficio. They exist merely for the purpose of enabling equity to work out a remedy. I think that happens when we go to court. Involuntary trust. And it's fraud. All right. I'm going to read the last part of this on page 14, and then I will make another video with 15. Constructive trusts do not arise because of the intent of parties that they shall arise, but often directly contrary to such intent. They are not intent enforcing trusts, but in a general way may be called fraud rectifying trusts. These trusts are created by courts of equity, not merely declared to exist as a result of acts of the parties. Whenever equity finds that one has obtained or now retains the legal title to property, real or personal, by any kind of wrongdoing, actual or constructive, so that a retention of such title will result in his unjust enrichment, equity may declare such legal title holder to be the trustee of a trust constructed by it for the purpose of working out justice. The trust is merely a convenient means of remedying wrong. The trust is merely a convenient means of remedying wrong. Is not a permanent trust in which the trustee is to have any duties of administration, but a passive temporary trust in which the trustee sole duty is to transfer the legal title to the sesticate trust. Naturally, if the reason why the holder of the legal title cannot equitably retain the beneficial use of the property is that such person is an express trustee, there is no occasion for declaring him a constructive trustee. The situations in which equity works out a remedy by a constructive trust are without number. An attempt will be made in the subsequent sections of this chapter to consider some of the more important instances in which constructive trusts have been created or seriously considered. Okay, I'm going to have to stop. It's getting late. It's like 2 hours I've been reading and going back and forth and trying to get my dog. So I will make another video about page 15 and onward. I think this has 34 pages, so we got up to page 15. That was pretty good. And I'm doing better with my coughing, clearing in my throat. Okay, well, I'm getting sleepy, so I'm going to have to finish now. You guys have a good night, and we'll see you at the next video.